This is Hap May with the Legal Play.
And I am Chelsea El-Azzi, Hap's associate. Hap, I'm excited for this topic.
Okay.
What happens if you lose the original copy of a will?
Okay. And I guess to go through the whole scenario, you had a will fully executed, all proper, signature, maybe blue ink just to prove that it's that, and client gets it, and somehow over the years or the time period they lose it, but somebody has a copy of it.
Yes.
Maybe the lawyer that
Man,
drafted
it'd be nice if they have a copy of it. We actually, I mean, to backtrack a little bit, we have had many clients who maybe did have a will and it just was destroyed or lost or something happened to it.
Right.
And they can, their spouse will come in and say, well, my husband or my wife died and I promised we had a will and this is what it says.
Right. And that's because basically they have a copy of the will to prove what the will said in the process, because that's the general assumption is, and what lawyers tell, we really need to have the original of the will, and we'll get into what happens if we don't. But I mean, the idea is that you submit the original of the will, and the authenticity is there. If you don't have the original of the will, then some questions start to get raised, and there is a presumption that comes into play, where it is, if you do not have an original of the will, the law will presume that the testator,
the person who made the will,
destroyed it with the intent to revoke. That's pretty harsh in the process. So that's why we want to have the original in the process. Sometimes you can overcome that presumption, and you can't. Best example is, I mean, the testator died in a fire that burned his house down. And you could see the said last will and testament, but the rest of it was all ashes. And then you go back to the lawyer, says, yeah, 3 weeks ago he came in here and this is a copy of it, and that you can kind of overcome the presumption under those type of circumstances. But there are cases when you can't, where you don't have anything. And then, I mean, we didn't try, because we ultimately settled the case. We had a big case maybe 10 years ago that dealt with a 30-year-old will, and the party that submitted the will for probate only had a copy of the will, and that named her. She was not a relative. She was some neighbor from 30 years earlier in California.
Okay.
And it was a $3 million estate, $4 million estate, something like that. And we represented, I think it was like 38 out of the 58 heirs at law that would take if the will was invalidated.
Oh, wow.
And all she had was the lady from California had was a copy of the will, and she was still able to present it, and the estate got to pay her legal bills because she had something presented. We were ultimately able to kind of convince her that she was going to lose and we were going to get the estate, and they were able to settle the case. Kind of after that came to the realization, and I think my guys got, my group got about a little over $2 million, $2.2 million.
I feel like that's kind of well, it depends on worst case scenario, depending on which side you're on. But if you are the testator, the one who created your will, and you want there to be, the distribution per your wishes upon your death, I feel like the worst case scenario is the will that you actually wanted to exist doesn't get applied. The court throws it out, or it's not followed because they don't have the original.
Right.
I recently worked on a case where the original couldn't be found. It just went missing. But of course, attorneys who draw them up usually do keep copies. And so there was an electronic copy that the executor was able to present to the court. In that case, though, statute comes into play with, well, what happens if you can't produce the original will? And a copy is not the original will. That's not the production of the will. If nobody's contesting it, then you're probably okay. If everything looks like it's pretty good, you know, there aren't any red flags or suspicious, you know,
Yes,
things going on. But the caveat is that you have to get notice to all of the heirs
right.
that potentially would take, saying, okay, this will has been entered for probate. There's an application. Hey, heirs, you know, do you have any reason to contest this? And if you can contact the heirs and the heirs say, no, that's fine. You can even get a waiver,
Right.
you know, a notice, waiver of notice. No, it's okay. You don't need to notice me. I'm not going to contest it. You file that with the court, moving on. But
That's
what if,
and that's the case. Sometimes the heirs, you're talking about a brother and a sister.
right.
You know, mom dies, and you had a brother and sister. In the case I was talking about, the testator died, didn't have any children, went up, had a bunch of siblings, but he was 90 when he died, and he was the youngest of 8 siblings, and so most of those siblings had died, and then they had children, some of whom had died, and grand. So we're looking at a big,
See,
and it
and
was impossible under those circumstances to identify with outcome court action who all of the heirs are. So
mhm,
sometimes that
yeah.
getting a waiver is not a possibility. But it is if you have a will that's signed and submitted, it's really an original that's really easy to do. The notice requirements are very limited. However, if you submit a copy, then you've got to get a hold of, basically ask, is anybody know whether or not there's a new will or whether this has been revoked,
Mhm.
and come forth
And
if you do that.
you know, there's public notice, there's notice that goes out, you
Right.
know, to anybody in the county who may know. And then of course you've gotta prove to the court that you notified all the heirs that you know about that could possibly, you know, have some
Right.
information or want to intervene.
Or have something coming if there is no will.
Right.
Because if basically you can imagine the situation where it is, brother and sister are the heirs at law. Mom gave everything to the sister in her will, but can't find the original of the will. Sister has a copy, she submits it. Is brother gonna waive?
The
You
waive
know,
notice.
or is brother going to come in there and contest? Hey, wait a minute, that's only a copy.
Yeah.
Presumed, destroyed with intent to revoke. I get half.
Yeah.
So that's kind of the deal.
And
Now, the other thing we're not covering here is that what if you have a will and you intend, that your daughter or your cousin or your a lawyer has a copy of it, but you actually intend to revoke it.
oh, what steps should you
Yeah, what
take?
steps should you take? I mean, in the process, and one of them is write a new will.
Yes.
And yeah, and so the new will supersede and revoke under its own terms the old will.
I would say
And
tearing it up is probably not the best thing you could do, because then that's just that disappears the original, and we're back to this. You know,
yes,
there's the copy
yeah, I mean,
with the presumption that can
taking
be
a
overcome.
big marker and writing revoked and then signing the words revoked and putting it back in, taking the original,
That's a better
putting it
idea.
back in the file, because then somebody that finds will find that original, and somebody says, "Oh, I got a copy of it," and then somebody else can say, "Well, I've got a copy
I've
of
got the
something
original.
that original
I've got
that
the original that
says
revoked. That's
revoked
actually
on it."
better.
Yeah,
Yeah.
something to that effect. Because there are people that they made plans change, they intend to revoke they revoke their will. Sometimes mom and dad go in and sign wills at the same time, kind of mirror wills. Then dad dies, and mom may have some different thoughts. Grandkids start to pop. In the case we have now, a real grandkid, not a will, but it's a lady bird deed. But grandkids sort of come into existence. Grandparents may want to leave something to them, particularly in cases where they get crossways with their children, but they want their grandchildren to get benefits. And when we talk about trusts and we talk about all kinds of different things, but things change.
Yeah.
And for that reason, somebody may want to revoke their will. And if they do, the best thing to do is write a new will.
Yes.
Or
But also write a new will if you're going to revoke. Going back to, if you want your original or you want your will to be adhered to, and the original is not found, and safeguard, where would you suggest these wills be kept? Because we have some people put them in a safe. Two cases I can think of. One was put in a safe, and we are in Houston, so it floods, and the safe was not watertight, and the will was destroyed.
I had an issue during Allison, the floods that hit the 2021, I think, no, 2001, I think, it's a little over 20 years ago, that flooded downtown, and my safety deposit box was in the basement of the Bank of America building.
Okay, so not even a bank
Yeah,
safety
yeah,
deposit
yeah,
box?
yeah. Now, fortunately, while there was some damage to those documents, you could make them out.
Okay,
You know,
they were
so there were a
salvageable.
couple of will, there was salvageable, there was not like a $2 million promissory note, but you could read it. I mean, it was a little damp, but you could read it. And I think the Bank of America has now moved their safety deposit boxes above ground.
So maybe if you're gonna put it in a safety deposit box, ask where they are, make sure they are, fireproof, gonna be in a safe place, above ground, where it's not
Put
gonna
them in a
flood.
plastic baggie and make
Yeah.
sure that it's, that's
Ziploc baggie, that's a good
Ziploc
idea.
baggie, they'll make sure that gives it some protection in case somehow something happens to it. So that's yeah, and keep it in that, it is good to let people who are going to be looking for that document, shortly after you die, to know where it is. That can be a little tricky.
I was gonna
It's
say,
just
how do you know you can trust them? Because in a case I had recently, the
Yeah,
children did know, and there's
first
suspicion,
one to find the original, reads it, see what they get,
and then
compares that to what they get if there's not a will, and either rip it up or submit it for probate, whichever
yeah,
is in their best advantage. So that's true. But letting know letting people know who the lawyer who drafted it was. Now that lawyer, that may have been, 10, 20, 30 years ago. So that lawyer may be not practicing anymore, may not be alive anymore, but that's, you know, at least knowing that and, keeping current as to where it is in the process. Uh, so those are some of the tricks with regard to what to do with a will in the process. Lawyers used to say, well, let me keep it. I've got a safety deposit box, or I've got a, fireproof safe or something like that. Problem is, what happens to the lawyer in the process? And the lawyer's created this obligation for the next 30 or 40 years to keep track of, the people he wrote wills for, which can create, some problems for the lawyer and problems for the heirs, because I'm not sure that somebody I did a will for 40 years ago, who might have had children at the time, or children were young and their children now grown up, and that person passes away, and their 40-year-old child says, well, who's that May?
yeah.
In the process, or who was the lawyer? I mean, certainly not that bald-headed old guy, was he?
Well, so I mean, I guess to wrap up, make a will.
Yes, make a will. Make sure it's done formally. Make sure that they have witnesses and it's signed as we do it, always in blue ink in the
Yes.
process.
And then safeguard the original
Right?
in a place that is going to be truly safe,
Yes.
preferably above ground and not gonna be destroyed by fire or water.
Right.
Then if you happen to be heirs or an executor and you can't find the original, know what you're gonna have to do as far as giving notice to interested heirs. If you can't get waivers signed, you have to give
You have to get
service to
services,
process.
and if it's a complicated where you don't know who the heirs are, it's not obvious who the heirs are, then there's an heirship process, of course, has to determine who the heirs are.
That can be long
Which
and
can be long and
cumbersome.
cumbersome, particularly in the case where I talk about all the different cousins,
Yeah.
you have 50 cousins that are involved.
And then you've got people having to track down
Right,
last
right.
known
So
addresses.
have a will, make sure that it's known where it is, make sure that it is safe, make sure it is the original. If you want to revoke it, make sure that you're loud and noisy about the way that you revoke it, and that you preserve evidence of the fact that it was broken, as we discussed, and write a new will.
I have a question before we stop,
All right.
because a lot of this time there's only one original. Can you execute multiples?
The problem that creates too many problems. The answer is no. You want to have one original, because the way it is you sign one original that revokes prior wills. You sign the second original, which revokes a prior will, which revokes that will. But then you got to figure out which will was it that was. So no, you have one original of the will.
Okay, so that means you have the one original. Keep it safe.
Yes.
And let the people who you know you can trust know about it and where it may be.
All right.
Okay,
This is Hap May with a legal play.
thanks, Hap.